You've probably seen by now, on Wednesday, January 7th, ICE agent Jonathan Ross shot and killed a motorist during an immigration-related operation in Minneapolis. The victim, 37-year-old Renee Nicole Good, a U.S. citizen and mother of 3, became involved or sought to legally observe the proceedings after dropping off her 6-year-old son at school that morning. She was shot in the head in the front seat of her car. The incident took place shortly after the Trump administration escalated immigration enforcement operations in Minnesota by deploying thousands of agents in the state. Diametrically opposed narratives have emerged over what led to the shooting, with the administration uniformly defending the agent's deadly use of force and seemingly everyone else saying he was 100% guilty of murder. Not surprisingly, it depends. But just hours after the shooting, the U.S. Department of Homeland Security issued a statement blaming Miss Good for the confrontation, characterizing the fatal shooting as an act of lawful self-defense. Homeland Security Secretary Kristi Noem told reporters that
when a mob of agitators that were harassing them all day began blocking them in, shouting at them, and impeding law enforcement operations. ICE officers and agents approached the vehicle. She then proceeded to weaponize her vehicle, and she attempted to run a law enforcement officer over. This appears as an attempt to kill or to cause bodily harm to agents, an act of domestic terrorism.
President Trump echoed these conclusions, insisting Miss Good, quote, viciously ran over the ICE officer, justifying the fatal confrontation. And as Vice President Vance has so eloquently put it, but videos posted online and witness accounts appear to contradict the official narrative. The reason this woman is dead is because she tried to ram somebody with her car. As we'll talk about in some depth, analyzed from multiple angles, the video footage seems to show Miss Good's car attempts to back away from officers surrounding her car and trying to force entry, and then lurch forward in an ill-fated attempt to escape confrontation. Mayor Frey has aggressively pushed back on DHS's version of events.
To ICE, get the fuck out of Minneapolis.
And now, as the country reels in the aftermath of the shooting, Minnesota investigators say that they have to withdraw a probe into the deadly use of force after being denied access to evidence by the FBI. Now, in a non-dystopian universe, the Justice Department would launch a comprehensive, non-biased investigation into the matter and, depending on the outcome, bring federal charges against the ICE agent who killed Miss Good. But right now, it's safe to assume the Trump-controlled DOJ will take no such legal action. Which raises the question, is Mr. Ross guilty of any crimes? And is there any feasible recourse to hold the agent liable for the death of Miss Good? Now, the fatal incident took place shortly after 9:30 a.m. on Wednesday in a residential neighborhood south of downtown Minneapolis, about a mile from where police killed George Floyd in 2020. A frame-by-frame analysis of bystander video footage raises serious questions about the administration's narrative that Agent Ross was forced to fire defensive shots to protect the life of himself and others. Video taken by a witness shows Miss Good's vehicle, a burgundy Honda Pilot SUV, stopped in the middle of a one-way road, its engine idling. And we're now starting to see more videos from the moments leading up to the shooting. It appears that the SUV was initially parked on the side of the road and was only in the middle of the road for a relatively short amount of time before the incident began. The video taken from Mr. Ross's own cell phone shows him filming the vehicle trying to apparently record the license plate of the SUV. Good's wife, Becca, was also using her phone to film him. She says,
"That's okay, we don't change our plates every morning, just so you know. It'll be the same plate when you come talk to us later."
And eventually Good herself says, "It's okay, dude, I'm not mad at you."
"That's fine, dude. I'm not mad at you."
And those were apparently her last words. Although bystanders were yelling at the federal agents and blowing whistles, it does not appear that Miss Good was engaged in that behavior.
Go home to Texas!
You can see federal vehicles start to approach Miss Good's SUV with lights flashing and sirens blaring. Agent Ross can be seen approaching from behind the SUV and crossing the SUV's right-hand side, all while filming the scene on his cell phone. In the crucial moments before the shooting, Miss Good rolls her SUV slightly forward into the street, then stops and waves at other motorists to go ahead of her. 2 agents are seen exiting his silver pickup and approaching the SUV, telling Good to... The SUV backs up, then veers forward to the right. Seconds later, gunfire erupts. Re-examining the scene from a closer vantage point, we see Agent Ross walk around the car while filming on his cell phone, disappearing from view. Other agents pull up and order the driver to get out of the car. But it's not clear who exactly those agents were or whether the driver could hear them. But it's clear one of the agents grabs the car's door handle and reaches inside, but is unsuccessful in forcing the door open. Almost simultaneously, you can see the SUV backing up and turning right in an apparent attempt to leave using a 2-point turn. At the same time, Agent Ross crosses towards the left side of the vehicle and grabs his gun with his right hand. To me, it looks like he unholsters his weapon before the car is moving forward. He opens fire on Miss Good and continues shooting as she drives past him. At no point does Agent Ross appear to drop the cell phone carried in his left hand, and that's bolstered by the footage he took on that cell phone continuously during the shooting, which we'll talk about in a second. Looking more closely at the moment Agent Ross fires, He appears to be standing to camera left of the SUV while the SUV's tires are pointed all the way to the right away from him. And things are happening fast, and it's not clear if Mr. Ross is in front of or partially in front of the car at the time that the first shot is fired, but it does appear clear that by the time the second and possibly third shots are fired, he is fully to the side of the vehicle. Reports are that the second and third shots were fired through the open driver's side window. It's unknown at this time which of the shots made contact or were fatal. This contradicts the administration's allegations that Ms. Good was running him over or attempting to run over Mr. Ross when he fired at her. Although other grainier video footage filmed from a different angle could appear to support this conclusion, but when this footage is synchronized with the closer footage, it's clear that Agent Ross was not run over by the SUV and in fact emerged unscathed. After being shot in the head, Ms. Good's SUV then veers into a white car parked further down the road before crashing to a stop. The agents witnessing the scene do not appear to rush to provide emergency medical care to Ms. Good. Eventually, Agent Ross approaches the vehicles and instructs his colleagues to call 911. Other agents can be seen blocking several bystanders who attempt to provide medical care, including one who identifies himself as a physician.
I go check a pulse.
No! Back up! Now!
I'm a physician.
I don't care.
Going back to the footage that Mr. Ross took himself, there's a couple of things that we can glean from this. Number one is that Ms. Good appears very calm as a driver, arguably snarky.
That's fine, dude. I'm not mad at you.
Which might have been her undoing. There seem to be conflicting orders. Some people are yelling, "Get out," some are yelling, "Get out of the car." You can also see clearly from Mr. Ross's vantage point that Ms. Good is looking all the way away from him as she backs up and also turns the wheel all the way to the right. In other words, turning to get out of that situation and not towards any of the agents. You can also tell from the footage that the engine is revving at this time, indicating that the car is going to speed up. But at the same time, this is all taking place at a very low rate of speed, close to zero, as she's doing what is obviously a 2-point turn. At the same time that another agent appears to be lunging into the driver's side door in an effort to apparently turn the wheel to the left towards the agents. You can also see Ross switches his phone from his right hand to his left that frees up his right hand to pull out his firearm. But it's also clear that he never drops the phone and continues recording in his left hand while simultaneously taking his firearm out with his right hand and shoots at least twice. It also seems pretty clear that the reason he was arguably in front of the car was for video recording purposes and that at any time he could have gotten out of the way. And I will opine at this time that holding your cell phone in one hand while firing with the other seems pretty reckless, if not depraved indifference to the human life.
You want to come at us? I say go get yourself some lunch, big boy. Go ahead.
Out of the car. Get out of the car. Get out of the car.
Now, given the Trump administration's refusal to participate in the investigation, and the fact that this video comes seemingly directly from Mr. Ross's cell phone, it's extremely likely this video was leaked by either Mr. Ross himself or someone in the chain of custody at the Department of Homeland Security, probably because they think that this video is exculpatory, which seems likely given that it was leaked to a right-wing news source. And as is the case in many instances, evidence can and often does support two diametrically opposed arguments at the same time. But from all angles, the video footage depicts a hostile, clumsy, and unnecessarily violent operation. Now, Minnesota officials have stated their intent to hold unlawful actors in the shooting incident criminally accountable. And to bring charges against a peace officer for the use of deadly force, the state must be able to prove beyond a reasonable doubt that the officer's use of deadly force was not justified. Section 609.066 of the Minnesota Code governs the authorized use of deadly force by peace officers. Now, assuming for purposes of this analysis that the offending ICE agent would be deemed a peace officer, which is not 100% certain, there's not a lot of case law on this, there is a possibility that a Minnesota jury could convict the ICE agent under the present circumstances. How likely that would be remains to be seen. Now, Minnesota's applicable statute permits the use of deadly force when, quote, an objectively reasonable officer would believe, based on the totality of the circumstances known to the officer at the time and without the benefit of hindsight, that such force is necessary to protect the peace officer or another from death or great bodily harm, provided that the threat can be articulated with specificity, is reasonably likely to occur absent action by the law enforcement officer, and must be addressed through the use of deadly force without unreasonable delay. Now, the statute also permits the use of deadly force to, quote, affect the arrest or capture or prevent the escape of a person whom the peace officer knows or has reasonable grounds to believe has committed or attempted to commit a felony, and the officer reasonably believes that person will cause the death or great bodily harm to another person unless immediately apprehended. As stated by the city attorney's office of Hennepin County, where the incident took place, this statute provides a, quote, significant defense to criminal charges brought against an officer accused of the use of deadly force. And under this defendant-friendly statute, it would be difficult, but not necessarily impossible, to prosecute Agent Ross for the unlawful use of deadly force. Turning back to the footage, Agent Ross might have a viable argument in his favor based on his first shot into Miss Good's SUV. At the time of the first shot, Agent Ross appears to be positioned maybe slightly in front of the SUV, which would be consistent with the corresponding bullet hole appearing in the front of the windshield in later footage. It is possible that a jury would believe an objectively reasonable officer would believe that deadly force was necessary to protect him or herself from death or great bodily harm when they're standing in front of, or at least partially in front of, a moving vehicle. The statute itself says that the decision of the peace officer to use deadly force is evaluated under the totality of the circumstances, which, quote, shall account for occasions when officers may be forced to make quick judgments about using deadly force. And you could certainly imagine a situation where a driver was driving 100 miles an hour directly towards an officer with the intent to kill that officer. Of course, this doesn't appear to be that situation. The SUV's tires here appear to be pointed away from Agent Ross at the time that the first shot is fired, which would undermine the self-defense claim under the state statutes. Her hands appear to be turning the wheel to the right. Further, at the time that the first shot is fired, the car is not speeding towards Agent Ross, but rather pulling away at an extremely low rate of speed. Thousands of motorists are pulled over every day. Revving the engine doesn't give the highway patrol a license to murder the driver. And it's much harder to make the argument that you were acting reasonably and fearing for your life while recording video continuously in one hand and pulling out your gun in the other like Akimbo Deagles. But certainly nothing is a given when prosecuting law enforcement officers, just ask Rodney King. And section 609.066 is extremely favorable to the officers themselves. But it's also possible that the analysis is different for the subsequent shots or shot fired by Mr. Ross and may not be justified under the Minnesota statute. Unlike the first shot that Mr. Ross arguably took in front of or partially in front of the vehicle, these later shots were taken from the side of the vehicle. Assuming that Ms. Good has committed some sort of felony here, the U.S. Supreme Court has addressed the use of deadly force in the apprehension of a fleeing felon in Tennessee v. Gardner. There, the court explained that, quote, the use of deadly force to prevent the escape of all felony suspects, whatever the circumstances, is constitutionally unreasonable. It is not better that all felony suspects die than that they escape. Where the suspect poses no immediate threat to the officer and no threat to others, the harm resulting from failing to apprehend him does not justify the use of deadly force to do so. Here, interpreting the Minnesota statute under the limitations imposed by Garner, it's difficult to conceive of any reasonable grounds for Agent Ross to believe that Ms. Good's attempt to drive away from the ICE agents would cause death or bodily harm to anyone so as to justify her shooting. Now, given that ICE is trying to add everyone's information to their databases, it's probably a good time to wipe all of your personal and private information off the internet. Your cell phone number, home address, email address, and private social media accounts, and tons of sensitive data are shockingly easy to purchase by anyone online. But malicious actors can't hurt you if they can't find you. And so you can fight back and take control of your private information by signing up for today's sponsor, Incogni. Incogni wipes your personal data from the internet by searching the internet, reaching out to data brokers and websites directly on your behalf, and forcing them to remove your private information. If they resist, Incogni will take care of that too, because Incogni fights back. But what makes Incogni truly powerful in taking back control of your privacy is the custom removals feature. It allows you to flag an unlimited number of sites where your data is exposed, and you can even have Incogni's privacy experts review and tackle the most uncooperative data brokers and people search sites. I've been using Incogni for years now, and in that time you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me in that time. I could never do this myself, so thank you to Incogni for weeks worth of work and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can always collect it and publish it again. So if online privacy is important to you, give Incogni a try. If you scan the code on screen or click on the link in the description, you'll get 60% off their annual unlimited plan. And you can try Incogni risk-free for 30 days. And if you decide you want to keep it, you'll still get the 60% off discount, so long as you use my code LegalEagle, all one word, at checkout. So sign up for Incogni, or I'll see you in court. And it also seems that any potential reasonability argument that Mr. Ross was in fear of his life evaporates the second he's to the side of the car. And additionally, use of force experts analyzing the video footage of the incident have also questioned Mr. Ross's decision to shoot at a moving vehicle at all. Most police departments, including Hennepin counties, discourage shooting at a moving vehicle because deadly force is unlikely to stop a car and could endanger bystanders. Now, it's also not 100% clear that an ICE agent qualifies as a peace officer for purposes of Minnesota's use of deadly force statute. And if so, then Mr. Ross could attempt to defend against a murder charge on the basis of self-defense under Minnesota law. But under this scenario, the state would bear the burden of proving beyond a reasonable doubt that Mr. Ross was not acting in self-defense at the time he shot Miss Good. But under these circumstances, Mr. Ross would find it difficult, if not impossible, to prevail on a self-defense claim, given that Minnesota's self-defense law applies only where the accused was not the aggressor and imposes a duty to retreat. To defeat a claim of self-defense, the state must disprove beyond a reasonable doubt that at least one of the four elements of self-defense, the absence of aggression or provocation in the part of the officer, to the officer's actual and honest belief that he was in imminent danger or death or great bodily harm, and that the action taken was necessary to avert that danger, the existence of reasonable grounds for that belief, and the absence of reasonable possibility of retreat to avoid the danger. And I think a jury would be hard-pressed to find that Mr. Ross did not engage in the aggression or provocation that ultimately resulted in the shooting. Video footage shows Mr. Ross approaching Miss Good's SUV, encircling it on the right side as he takes video with his phone, and re-emerging near the driver's front side of the car. And he first draws his gun as the SUV reverses away from him. And while the aggressor in an incident generally has no right to claim self-defense under Minnesota law, an original aggressor can still claim self-defense if he actually and in good faith withdrew from the conflict and communicated that withdrawal expressly or impliedly to his intended victim. But here, the video footage shows no withdrawal or communication of withdrawal. To the contrary, it shows Mr. Ross originally instigating the incident and then proceeding with the escalation of tactics, nearing the vehicle, drawing his weapon, and aiming it at Miss Good. And another hurdle facing Mr. Ross in a self-defense analysis is his failure to retreat. A valid self-defense claim requires the, quote, absence of a reasonable possibility of retreat to avoid the danger. And the Minnesota Supreme Court has explained that a reasonable opportunity to retreat exists if there are, quote, options for escape or avoidance of peril rather than directly confronting someone. And here the video footage shows that Mr. Ross had time to get out of the way of the SUV because he did. Mr. Ross was not trapped. He was not unfettered in his ability to escape, back away, or otherwise protect himself. And in fact, he had the opportunity to take out his gun and shoot the driver. If I was the prosecutor, I would certainly argue that a reasonable officer would have done everything that they can to get out of the way first, before even thinking of unholstering their firearm. And of course, maybe put the video camera down too. Mr. Ross did neither, and still was seemingly unscathed. This failure to retreat or safely avoid the confrontation before resorting to force likely dooms any claim of self-defense in a non-peace officer scenario. On top of that, the state could argue that Mr. Ross did not have a reasonable basis to believe that he was in imminent danger of death and that the discharge of his firearm was necessary to avert that danger. That's because an objective standard applies to the amount of force used. In other words, the force must be proportionate to the threat and limited to that which would appear to be necessary to a reasonable person under the circumstances. Lastly, it's come to light that Mr. Ross is a 10-year veteran of ICE and was involved in the prior months in a similar situation that did result in his injury. And although Mr. Ross would likely argue that his past experience of being dragged by a car in a previous ICE enforcement operation demonstrates his actual and honest belief that he was in imminent danger of death or great bodily harm, the state might use that same evidence to show that he was still traumatized by that incident and his belief was unreasonable. Now, as if the shooting itself couldn't have gotten any worse, towards the end of the video footage, we see other federal agents impeding a physician's attempt to render aid or to check the pulse of Miss Good as she lay slumped over the steering wheel of her car. Witnesses also report that ICE vehicles blocked an ambulance that arrived on the scene. These obstructions of medical aid could prove further grounds for liability against the agents under Minnesota law. Minnesota Statute Section 609.662 imposes a duty to render aid to shooting victims. Specifically, the statute provides that, quote, a person who discharges a firearm and knows or has reason to know that the discharge has caused bodily harm to another person shall, 1, immediately investigate the extent of the person's injuries, and 2, render immediate reasonable assistance to the injured person. If the victim suffers death or great bodily harm as a result of the discharge, the person who discharged the firearm is subject to imprisonment of up to 2 years and or fines up to $4,000. Here, although Mr. Ross does appear to take his time in checking on Miss Good's condition and instructing his colleagues to call 911, his response might be deemed inadequate given that he's whisked away just seconds later. But it's also possible that response does meet the statutory obligations. Now, to the extent that ICE agents might have deterred bystanders and ambulances from reaching Miss Good to administer aid, those agents may also be liable under Minnesota Statute 609.50, which prohibits the obstruction of legal process. That law subjects liability to anyone who, among other things, intentionally interferes with or obstructs a member of an ambulance personnel crew who is providing or attempting to provide emergency care. And the reports are that it took a significant amount of time for the ambulances to appear. ICE agents did not allow ambulances to park next to the victim, and as a result, they were forced to walk a significant distance to render aid. And the penalty for any such violation where the accused knew or had reason to know his obstruction created a risk of or actual death or substantial bodily harm is subject to imprisonment of up to 5 years and fines of up to $10,000. And less significantly, Minnesota's Good Samaritan law imposes a general duty to assist a person at the scene of an emergency who is exposed to or has suffered grave physical harm, but the violation of this law results only in misdemeanor liability. And finally, criminal liability may also be available for the other ICE agents involved in the obstruction of medical care if it's found that these officers' actions or failures to act resulted in a death that could have been prevented by earlier medical treatment under Minnesota Statute 609.205. With all this said, it remains unclear whether the state will in fact press charges. Minnesota Attorney General Keith Ellison has stated that anyone who broke the law as part of this incident will be held accountable. And the Hennepin County's Attorney's Office has already stated it has jurisdiction to bring criminal charges against federal officers involved in the shooting. Although the Minnesota Bureau of Criminal Apprehension initially said it was partnering with the FBI to conduct a joint investigation into the shooting, it later announced that it has been notified by the FBI that the investigation would be led solely by the FBI, and that the Minnesota Bureau would no longer have access to case materials, scene evidence, or investigative interviews necessary to complete a thorough and independent investigation. The Bureau further stated it may not be able to present a case for prosecution without access to evidence gathered at the scene of the fatality, especially when it's in the possession of the federal government. But then, of course, there are the immunity issues. Now, despite what noted Yale Law graduate, J.D. Vance says, federal officers do not have absolute immunity simply by virtue of being federal agents. This is, at best, a misunderstanding of established law. The Supremacy Clause of the Constitution does provide some immunity, but it does not give federal officers automatic immunity from state criminal law. We've talked a lot on this channel about qualified immunity, but that's in the context generally of civil suits against state law enforcement officers. Here you have the potential of state criminal law applying to federal officers. That doctrine comes from cases that we've actually talked about many times, like In re Nagel, which held that states cannot prosecute federal officers for actions that were authorized by federal law and necessary and proper to carry out federal duties. But that protection is conditional. It's not enough that the person is a federal officer or was on duty. Courts ask whether the officer was performing a federal function and whether the specific conduct was reasonably related to that function. If the conduct was excessive, reckless, or unrelated to legitimate enforcement needs, the Supremacy Clause arguably doesn't block state prosecution. So the legal question is not, was this an ICE agent, but was this killing necessary and proper to carrying out federal immigration law? The Supremacy Clause defense is fact-intensive and usually cannot be resolved just by holding up a CBP or ICE badge. States may prosecute federal officers if they act outside of the scope of their federally authorized duties or violate state criminal law in ways that are neither necessary nor proper to carry out their mission, but there aren't really many recent examples of state law enforcement charging federal agents. But it does happen on occasion. In a case called Battle versus State of Maryland, a state court allowed the criminal prosecution of a federal DHS agent to go forward after he assaulted someone during an off-duty altercation at a convenience store. Mr. Battle claimed that he had a right to make a warrantless arrest of the victim he got in an argument with, but the court held that the Supremacy Clause did not protect him because he was not carrying out a federal duty, and his actions were neither necessary nor proper to enforce federal law. The court found that Battle had a personal motive to stick up for himself instead of by desire to perform his governmental duties. But this particular case is different because the agent was on duty, apparently and arguably enforcing immigration law in the neighborhood, which drew a crowd. And the video and witness statements indicate that the ICE agent got into a verbal argument with Good and her wife before he opened fire. And you can see in the video, it shows the agent trying to film their license plate. Good's wife said, "We don't change our plates every morning, it'll be the same tomorrow." She then tries to get back in the car. And we know that CBP and ICE agents are now photographing and scanning people they encounter to add to their various databases. But was the shooting necessary and proper to the governmental functions? Well, it depends on what level of abstraction you're talking about. Clearly, he's part of a general ICE operation, but then if you dig into the specifics of actually firing the weapon, that analysis might dovetail with the self-defense analysis that we already talked about. And the Supreme Court hasn't decided a Supremacy Clause immunity case in more than 100 years. So where does that leave us? Well, with a two-part test articulated in the Nagel case, whether the agent's acts were A, authorized by federal law, and B, necessary and proper. And on the first prong, courts disagree about what degree of authorization is necessary. And the second prong evaluates the agent's reasonableness, but courts seemingly don't agree with each other on whether the use is a subjective or objective standard. In the case Wyoming versus Livingston, the 10th Circuit reviewed whether federal officials and a contractor could be prosecuted under state law for trespass and littering after they unintentionally entered private land while capturing and collaring wolves as part of a federal wildlife program. The defendants transferred these state charges to federal court and argued they were immune under the Supremacy Clause because they were performing their federal duties. The appeals court held that they were entitled Supremacy Clause immunity, meaning the state of Wyoming could not criminally prosecute them for actions taken in the course of federally authorized work. The court reasoned that federal law imposes an obligation on the agents to monitor wolves and that the agents had an objectively reasonable and well-founded belief that their actions were necessary to fulfill their federal duties, even though they were not authorized to trespass. Now, many people on social media will insist that Minnesota authorities can charge Ross with murder based on the video alone, but Minnesota officials will have to consider all of these factors before making a charging decision, and they'll also have to gather a huge amount of evidence. And if they do charge Mr. Ross with a crime, he'll obviously seek to remove that to federal court, and then they will battle over Supremacy Clause immunity. But to that end, the Hennepin DA wants people to send in videos and photos of the killing to their office so that they can develop an independent body of evidence. It appears the FBI took shell casings, car, and other physical evidence that they would normally use to prove how the crime occurred, but it's not clear that the FBI will turn that evidence over to the state. And you'd hope that the federal government would cooperate with the investigation, but so far it looks like the Trump administration will do everything it can to stymie it. But since murder has no statute of limitations, it's possible a future administration could still seek to hold Mr. Ross liable for the killing of Miss Good. But that's assuming that Trump doesn't issue a preemptive pardon for Mr. Ross before leaving office, though ironically, a federal pardon wouldn't stop a state prosecution, but then we go back to federal immunity questions. But even if the Trump administration obstructs the state's access to evidence, the video footage may already be enough to secure conviction. It's certainly not an easy case. It never is when you're trying to prosecute a putative law enforcement officer, but sometimes it's worth the risk. Now, all this highlights why it's so important to get a great lawyer when you're dealing with your own case. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems, and they'd ask, can you help me find a lawyer, or how do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel? Transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front, and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.